Welcome back, everybody. It is 4:15. So, Ms. Sillison, if you'd like to carry on with your cross-examination. Thank you.
Thank you. I was going to move on to visual impacts, Mr. Petro, but I just want to finish off, sorry, this point about the differences. So we were in the Appendix 4 to the Statement of Common Ground. We were looking at the table against the application site receptor. You identify the magnitude of effect as being high adverse year 1 and year 15. It's that high magnitude of effect that effectively drives your significance of effect as being high adverse, isn't it?
Degree of change, yeah.
Yeah. So can I just ask you then, please, to turn back to your proof of evidence. And in your Appendix A, you have a table which is the magnitude of change. So that's page 28 of your proof of evidence. And this is the sort of criteria against which you have judged the magnitude. And so for a high adverse magnitude of effect, you tell us that that would arise from the introduction of major new elements into the landscape not currently present, or some major change to the scale, landform, land cover, or pattern, I think that must be of the landscape, loss of resource and or quality and integrity of resource, severe, I think, rather than severe damage to key characteristics or elements.
Thank you.
Is that the basis upon which you concluded that the magnitude of effect would be high adverse?
Yes, and that there is the introduction of a major new element within the rural landscape, that is the housing. The housing isn't currently present within the appeal site. And there is a major change of the scale of the landscape in that respect, that it's going from undeveloped countryside into housing.
Have you taken account of the fact that 2/3 of the appeal site will be undeveloped?
I have, in that those areas would be undeveloped and given over to open public space. That's still, in my view, an adverse change. There's a urbanizing effect of those open spaces. They're clearly quite different to open countryside.
I see. And again, I mean, there's no explanation in your proof of evidence to justify any of that, is there?
Well, I've given it to you now.
No, answer my question. There is nothing in your proof of evidence to justify that magnitude of change as set out in your evidence.
Agreed, but we discussed it just now.
Thank you. All right, let's just turn to the visual impact. So if you turn over the page, in the appendices, we can see that it is...
So we're at the Statement of Common Ground?
Statement of Common Ground.
Thank you.
So we're talking really about the footpaths, aren't we? And then to some extent, the public open space to the west of the site associated with the Taylor Wimpey.
Yeah, so we concern particularly of public views.
Yeah. All right. Now, as I think we established at an early point, in terms of the visual assessment, the process is the same in the sense that to understand what the significance of the visual impacts are, it's a combination of sensitivity plus magnitude of change. And sensitivity is itself a product of susceptibility and value.
Mm-hmm.
And we've established at the outset that your proof of evidence, your appendices with the methodology, doesn't actually give any clue, doesn't contain a table that would allow anyone to understand how you had arrived at either sensitivity or value.
Agreed.
Your table on page 29 is the product of value and susceptibility. It's what the sensitivity is.
Agreed.
Yeah. All right. Now, in terms of value, you haven't disagreed with the LVA and the methodology that is provided there.
No, it's the judgment that we're disagreeing on.
Okay, so because you haven't done the exercise and there's nothing I can ask you in your proof of evidence to test your assessment of there being a high value to the receptors, can I ask you please to turn up the LVA? So that is core document 2.15. It doesn't have any internal page numbers, but I'd like you to turn to PDF. PDF 96.
Sorry, could you turn it back again we're going to?
So I'm taking you to the LVA.
Yes,
So
sir.
that's CD 2.15. When you get to the CD, then I'll take you to the PDF number.
CD2. Oh,
CD 2.15.
I've got it here for some reason. CD2.
CD 2.15.
I've got CD2 additional application documents. CD 2.1, 2.2. Oh, sorry. Here we go. My apologies. Okay.
Yeah, and if you turn to PDF, page number 96, should be 96 of 103.
There's no page numbers.
No, that's why I've given you the PDF number, where he said there are no internal page numbers. So if you look at
96.
96 of 103.
This was the table 4.
Table 1.4?
1.4.
Brilliant. Okay, so in your proof of evidence, just keep that page open. In your proof of evidence, in your table 2, for the receptors, the public rights of way, you attributed a high descriptor to the value.
Yes.
Yeah. As I say, nothing in your proof of evidence that would allow us to understand what high in your world means. Let me ask you this first of all. What is the scale you're working to here? Is high at the very top of the tree?
Yes.
High is at the very top of the tree, is it?
High is most important.
Okay. So if you look at table 1.4, this is the table that was used in the LVA that you haven't criticised, that Turley's used to assess the value of the attached to the views of the receptors of the which they then look at the. So this is their scale. Now they have a very high, medium, etc. If your high is at the top of your scale, that would equate to very high in her scale, wouldn't it?
No, I would accept that my high is, I'm not being rude, her high.
Sorry?
I think my high is the same as her high.
Okay, so actually you do have you're going to change your evidence again.
No,
Actually, the top of the scale is not high, it's
No,
something more.
I was trying to answer a question looking at my proof here, that my high is the highest, but they've got an additional high, which is very high. We're not within the very high, within the high, which is my high on page 29.
Okay, well, let's test that then, shall we? So, Ms. Eads' high, which you say is now also your high. So a value which falls into that high category is one which is either national or regional. Now, that's clearly not the case, is it? First question.
Let's agree with you for the time being. I'll come back to it, but let's agree with you.
And then give some examples. Designated views of national or regional importance. For example, views of noted importance to sites of national importance. Further examples, scheduled monuments, AONBs, grade 1, grade 2, listed buildings and or registered parks or gardens. Clearly, the receptors on these footpaths do not fall into any of those typical examples, do they?
No.
Yeah?
I agree.
Yeah. So if your high is the same as her high, then you would agree that it doesn't fall into that category.
I think we need to go back a stage and try and explain why I think it's high rather than the medium in 96. It's about guidance. It's about the whole sort of thrust of Givler is about it provides a guidance for a practitioner to then use, and there's always going to be some variation in how different practitioners view and apply the guidance. It's accepted that the views in public footpaths aren't towards a national landscape or a national park. There's a view of a listed building, which is St Andrew's Church, down to the south. But in my view, and why I think it's high, is the importance of these views for people escaping the urban area of Farnham, and this absolute delight and joy in being able to, the moment you out your front door just about, to being in an open rural landscape. So my interpretation, my judgment here is that though we're not looking at a nationally important landscape, we're looking at a landscape which is really important to the people who are using it. So I'm making a judgment call and saying it's high for those reasons.
Yeah, but you see, the difficulty with this is we don't have any analysis by you in your proof of evidence. We don't actually have a table whereby we can test what you mean by high, because you just haven't bothered, quite frankly, to put one in.
Well, that's not quite right. We're testing, you're testing how I've come to that high. Now do my oral examination.
Well, yeah.
So the inspector's hearing that, and the information is coming out to her.
And I mean, where would I find a table that would allow you, me, the inspector, anyone else in this room to understand that when you say high, that's what you mean in terms of the explanation you've just given us?
Well, you won't, but that's my explanation. That's the purpose of cross-examination, I presume, is to test why I've come to the term high, and I believe I've given to you. That's my judgment. That is, I'm firm of the view that these are high for the reasons that are given.
That is because there is this transition from the urban area.
This unique experience that people have so close to an urban area, and these open views, and that so many people are making this active choice to come out and walk these 3 footpaths. It's got to be high because of the use and the experience that people are getting, and the fact that it's not within a national landscape, in my view, in this case, doesn't actually matter. They have these really pleasant, open views that are good for their health, their enjoyment, for their mental health, physical health, whatever else. And my view, my judgment call, that's high.
Okay, where would I find in Glivia or any other Landscape Institute document or any other landscape guidance note which would suggest that merely because footpaths are used, well used in the way that you've described, would give them a high value?
You won't, that's what I'm saying, that the purpose of the document is for guidance, and it's about applying that guidance, and that's how I'm applying it.
And it's right, isn't it, that they're not, I mean, they may well be valued by local people. I don't accept
I think they're highly valued by local people.
I really would like to finish the question.
My apologies.
People who run do not necessarily in the countryside. I run in myself in the countryside, do not necessarily run in the countryside because of the views. People who walk their dogs do not necessarily walk their dogs in the countryside because they value the views. That's correct, isn't it?
No, I think if you're making a choice to use a particular footpath, you might well be taking a choice to enjoy a particular view. I walk my new dog every day. I walk her sometimes in Beverley Park because it's close by and we can walk there, we can walk back. Other times I make an active choice to go to Richmond Park or Bushy Park or Home Park, where the views are extraordinary.
And that's my point.
I'm making that active choice depending on time, weather, whatever else. So I think people are making an active choice to walk these footpaths for those views and for that landscape experience.
But you've just contradicted yourself, Mr. Petro. Sometimes you take your dog out for a walk just to walk the dog, to exercise it. The view is unimportant. Other times you choose to walk your dog in a place so you can enjoy the views. I don't think the dog cares too much about the view.
Well, I'm sure she does.
So that's exactly this position here. You have no idea whether those people who are walking their dogs on these footpaths are simply exercising their dog or they are taking their dogs so that they as humans can enjoy the view, do you?
I make an assumption they're walking those footpaths for the view because there are other footpaths closer to Farnham. You can walk down the footpath between the university building if you choose to. The views, in my view, is pretty miserable because you're looking at buildings. So people, why are they walking in this open landscape rather than walking the footpath that's equally as close between the two buildings? My view is part of the reason, the important reason why they're walking these footpaths is for the view. Otherwise, you walk another footpath, and that's why when I visit the Sunday morning, there's so many people using it.
Okay. Now, can I just ask you? I think that the last matter I want to ask you some questions about is in your proof of evidence. You seem to attach importance to the views from private residences.
Mm-hmm.
Now, that's not a point I think that's ever been made before, is it? Before your proof of evidence.
So I don't quite understand the question.
Your evidence that there is an adverse impact on the private views of residents, i.e. from their homes, is not a concern that's been expressed before your proof of evidence, was it?
It's expressed in the LVA. There's a commentary on views from residents, from properties.
But there is no, well, point me to the reference, which says there's adverse impact from residential receptors, if you can. But the Glivia guidance, and indeed the clarification which you refer to, and you say that you've taken into account in your proof of evidence, makes it clear, doesn't it? Certainly in the clarification, that's the clarification at 6.1, that.
So 6.1 where, sorry?
So it possibly isn't in the core documents. It's the document you refer to in your proof of evidence as you having taken it into account. So if you want to turn up your proof of evidence, do you see at paragraph 3.1?
Yes, yeah, I can remember it.
You say you've looked at Glivia, your methodology uses Glivia, debate, but then you also say that you've also had regard to the Landscape Institute's notes and clarifications on aspects of guidelines.
Mm-hmm.
That's the August 2024 documents. Now, I'm just going to ask you this because you've looked at it, obviously you're familiar with the document. Page 15, under the heading of assessment of visual effects, the clarification.
So page 15 or what, sorry?
15 of that document?
Well, this witness must be allowed to look at the document.
Well, I think, I think if you're going to ask questions, he either needs to see it
No,
or
I'm
you need
happy to read
it.
it out.
I'll read it out.
It's cool. Well, we can come back to it. after.
Well, Madam, context is
think-
important. If this witness is going to be asked questions about a doc,
Have a look at it. Only when you read 6.1.
Is this in the core documents, Mr.
No, I
Little?
think it's not, so it might have to go in.
Yeah, in which
Document
case,
be
if you,
reversed.
could you arrange for a copy to be
Yes, of
submitted
course.
if you want me to?
Do you need to
look
read
at it?
this after me or?
No, I'm happy to listen to
Okay.
the questions, but if I'm going to put anything to it, then I need to have a copy, please.
Okay.
So 2 points. It reflects the accepted position that private views are not, well, I'll read that. Views from houses and individual properties are a matter of private management. It's an established planning principle. There is no right to review. Yes, so this is in the context of the clarification that's provided to Glivia and whether or not people living in houses should be considered as receptors. And it goes on to say, views from houses and individual properties are a matter of private amenity, noting that it is an established planning principle. There is no right to a view. It may be helpful for an LVIA to comment on changes to views that will be experienced from groups of properties, or in some cases, individual properties, if these changes are likely to be significant. So first question, are any views from private houses likely to be significant?
No.
No. And then, so if they're not significant, then it's not helpful to even comment on the changes, is it?
Well, that's a matter of opinion. I think in this case, again, judgment call, I think it's likely, prove it, disprove it, one can't, it's likely that people who live along the roads that face onto the appeal site might well have bought those properties because of that view. There's no right to a view, but that view is going to be changed. It's going to change from an open view over the countryside through the poplar trees to a housing estate. It's a commentary saying there's a change of the view. They are a receptor. I think it's worth mentioning how much weight the inspector chooses to place on that. Of course, is up to her, but I think it's worth pointing out.
Well, let's ask that question. I mean, are you suggesting that the inspector should refuse planning permission because of your assessment of the impact on private views?
The inspector will make her
No.
own mind up.
Are you inviting, very specific question, Mr. Petro, are you inviting the inspector to refuse planning permission because of the impact on private residential views? That's a
No.
yes or no?
No.
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 Right, thank you very much. That, I think, is it. Thank you very much, Mr. Petro. Thank you.
Thank you, Mr. Lisson. Are there any questions from any interested parties that had spoken that would like to ask a question, Mr. Petro? No? Mr. Free, you have one?
That's a difficult question. It's a national footpath, so it has a higher status, a higher value. I think that the short answer to the question is yes.
I just say,
And-
it's a little unusual that objectors should be able to ask questions of counsel who are objecting to the,
No, but I'm happy, I take your point, but I don't think it's,
Yeah, well, I've let it slide this time, but I don't, as a matter of principle, I don't think that's, frankly, it's unfair.
well, I'm happy, would you like me to disregard the question there, Mr. Lynn? Mr. Lynson?
I'm happy to take that answer, but I think, I'm not sure that it's a practice that should be encouraged.
Okay.
See what I think.
I take your point, thank you. Mr. Petro, I just had two questions, one of which I think you answered, which essentially was, do you consider the magnitude in respect to the footpaths mitigated by the proposed park element, the open space element of the proposed scheme?
My view is no.
There's no. And then the second part of that question was that this is obviously an outline scheme. If the open space element was specifically landscaped at reserved matters or not landscaped, as the case may be, so that it maintained or retained a rural nature, would your view change in that respect in terms of mitigating?
No, because I think the important point is the built form element. And that's what we're concerned about. And that's how the views change from rural to settlement.
Thank you. I don't have any further questions. However, please remain where you are. And Mr. Green, if you'd like to re-examine.
I have no re-examination, madam.
That's fortunate, isn't it? That was all the evidence that we were due to hear today. So we've got through it quite succinctly and it's 20 to 5. So I don't propose that we move forward onto planning evidence this evening. I don't think that's a good use of time. And I think we will deal with Joanna's evidence tomorrow, Miss Eade's evidence tomorrow. So, sorry, namesake, so I couldn't help myself. Are you happy with that, Mr. Listen, because of your timing.
Going to get through the evidence tomorrow. I mean, I think my preference would be to get Miss Eade's evidence done in chief tonight. I think in view of the narrowing of the disagreement.
If you're confident that that can be done before 5:30,
Certainly
but
by
I'm
before
not,
5:30,
I'm not
I'm
sitting
thinking
after
half an hour.
5:30.
No, I'm thinking half an hour.
Right, okay.
If you're happy with that, I mean, if you don't want to, then, you know, we'll just have to be really efficient tomorrow.
No, I'm happy to be guided. And what I don't want to happen is for tomorrow to end up being in a situation where we end up sitting very, very late because obviously you're not available the following day.
Exactly, so I'd rather.
So I'm happy to take it, but like I say, I'm not sitting after
No.
5:30.
Understood. Okay, well, let's do that and see if there's, that we are not going to go beyond 5:15.
Mr. Green, are you happy with that?
Entirely, madam, yes.
Okay, in which case, Mr. Petro, thank you. And Miss Eade, if you'd like to come make yourself comfortable. In terms of tomorrow, can I just flag up, it's very, very useful if the advocates can provide a list of the core documents that they intend to refer to when they begin their, yes, because it saves this jumping around. Thank you.